Hi, my name is David Fraser, and I'm a privacy lawyer with the Canadian law firm McGuinness Cooper. There's a recent case out of Alberta that I thought was pretty interesting. The court there held that the Know Your Customer requirements for scrap metal dealers violate Section 8 of the Charter as an unreasonable search, and that the law effectively turns scrap dealers into state agents collecting personal information on behalf of the government and the police. In the King and Khairullah, the Alberta Court of Justice was asked by an accused to declare that an Alberta law's requirement that scrap metal dealers collect personal information from scrap metal sellers, which is then entered into a police accessible database, is an unreasonable search under Section 8 of the Charter. It's interesting that the accused is a scrap metal dealer and not a person whose privacy was directly or allegedly violated. So the court found that requiring a private business to gather personal information from a lawful seller of scrap metal made the business an agent of the state, and the breadth of personal information and how it was stored resulted in a violation of Section 8 of the Charter. I think this decision may have some broader application in other Know Your Customer contexts. Section 3, Sub 2 of the regulations made under the Act require personal information from individual sellers to be provided to a police officer or a law enforcement agency by entering the information into a database maintained by the minister designated under the Act, and the police are given access to that database. This information includes name, address, ID, particulars, business name, if applicable, and vehicle details. So the accused argued that the statute turns scrap metal dealers into law enforcement agents by requiring them to collect and record personal information of individual customers at the behest of law enforcement. It's not information that they need to run their business, it's entirely for the benefit of law enforcement. And the court considered four interesting hypothetical scenarios to illustrate whose information may be collected and what their relationship may be to the underlying transaction. So hypothetical number one, the scenario is a married couple in their 60s intending to downsize and retire. They collect scrap metal stored in their garage, basement, and backyard of their residence. The scrap metal was collected during a hobby of car restoration undertaken by the couple over a period of years. The scrap metal is loaded into the couple's half-ton truck to transport to a dealer for recycling. And the court then says John Doe is the driver of that vehicle, loaded with old car parts to be sold at the dealer. John Doe gives his driver's license to the dealer. The dealer records that John Doe has arrived to sell the metal in a 2023 F-150 pickup truck. The dealer records the license plate, the make, the model of the Ford F-150 truck. The dealer requires John Doe's home address, and all of this is entered into the database accessible to law enforcement and peace officers. So here's hypothetical number two. A woman in her 40s operates a small home-based arts and craft business creating metal sculptures and wall art. She's accumulated a large amount of bronze, copper, and other metal pieces. She decides to take the metal to a scrap metal dealer for sale and recycling. Now she's Jane Doe. She arrives at the dealer in her 2020 Toyota SUV. The dealer records her Alberta healthcare card information, her residence address, her vehicle, make, model, and license plate. The data reveals that she is a female living at a specific address in Southeast Calgary with a valid Alberta healthcare card, driving a black Toyota SUV year 2020 at the point of sale. So here's the judge's third hypothetical. You have two college students. They've collected scrap metal from yard sales held all over the city of Calgary over a period of months. They decide to load the metal into their father's truck and transport all the metal to a dealer for sale and recycling. So the college students arrive at the scrap metal dealer's place of business in their father's 3/4-ton truck, which is used in the father's business. The students must provide to the dealer a driver's license. The students live with their parents, so they must disclose their home address, which is in Northwest Calgary. The name of the father's business is on the side of the panel of the truck, and the dealer records this along with the make, model, license plate, and color of the father's truck used to transport the scrap metal to the dealer for sale. So here's hypothetical number four. A couple in their 30s are engaged in annual spring cleaning in their yard and residence. They have an abundance of scrap metal from a failed restaurant business. They borrow a friend's half-ton truck to transport the metal to a dealer for sale and recycling. So here's the analysis. The couple engaged in spring cleaning arrive in a neighbor's truck, which they have borrowed to transport the metal to the dealer. The couple, that is the driver, must provide a driver's license, personal residence address, and the details of the friend's vehicle in which the metal was transported, including the make, model, and license plate. The court noted that in all of the hypotheticals of individual sellers of scrap metal, the dealer is able to obtain and record information as to where each individual lives, what quadrant of the city, what type of vehicle is driven to engage in the sale. In the case of one of the sellers, the judge notes personal health card information. In the case of the other sellers, driver's licenses with photographs and residence addresses. The seller is also able and required to gather information about third parties, friends, relatives, and neighbors who have loaned their vehicle to the individual sellers who transport the metal to the dealer. The accused argued that the information collected attracted a reasonable expectation of privacy, while the government argued that privacy interests are of less importance in a regulatory legislation environment as opposed to criminal law. The court noted that in determining whether a search power is unreasonable under Section 8 of the Charter, the courts have historically distinguished between criminal law and regulatory law. But, the court concluded, this bifurcation between criminal and regulatory law is artificial with respect to the analysis of privacy rights. Rather, the underlying question for both criminal and regulatory law is assessing reasonableness, is whether the law achieves a reasonable balance between individual privacy rights and the state's interest in deterring crime. The government further argued that the provision of the information was voluntary and informed, as sellers are presumed to know that this information is collected and will be stored accessible to law enforcement. I'm not sure they understand what voluntary means. The court took a different view and wrote, at paragraph 34, the court strongly disagrees with the minister's characterization of the sales transactions as voluntary. In fact, there is no other reasonable alternative for citizens, individuals in Alberta who wish to dispose and recycle scrap metal other than through the regulated procedures of this legislation. It is a fact that scrap metal cannot be placed in the garbage bin curbside for weekly disposal. The court concluded that the data collected breaches privacy interests of individuals who simply wish to dispose lawfully of metal, and it is unreasonable. The court wrote in paragraph 37, the additional issues is that the statute not only mandates gathering of this personal information, but requires the storing of this personal information in a database with no overriding charter protection, requiring law enforcement to have reasonable or probable grounds to search the database. All of this is unreasonable and overbroad, the court said. The court then goes on, in paragraph 38, if personal data of individuals is to be retained for future use of law enforcement, then law enforcement should have reasonable and probable grounds in order to actually search the database of the information stored. None of this is present in the legislation in terms of protection. And then the court goes on at paragraph 39, it is entirely unreasonable to record the make, model, license plate of the vehicle that is used by the individual to transport metal and to collect and store personal information, which includes all of the information the court has identified in this decision. This is overreach. It is overly broad. It is a gathering of too much personal information. And then the court says, in short, the statute in this case does not achieve a reasonable balance between privacy and the state's interest. The court concluded that in the scheme established under this act and regulations, the scrap metal dealer is an agent of the state who is forced to gather information that amounts to an unreasonable search and seizure in contravention of Section 8 of the Charter. I find it interesting that the court focused more on the collection of the ID information and not as much on having it to be entered into a database to which the police are granted real-time access. There was some discussion of that, but that availability and warrantless search at the police's convenience, I think, could use a little bit more discussion and a little bit more analysis. Now, I think this case may also have implications in other circumstances where laws require a business to collect personal information and make it available to the police without a warrant. I'm reminded of a situation from British Columbia where a shooting took place in a restaurant's parking lot, and the police asked for the CCTV footage. The restaurant, properly in my view, said, come back with a warrant. And the Minister of Public Safety was outraged. As a result, the province amended their liquor license to require surveillance cameras and make it a condition of their liquor license that they just hand the surveillance footage over to the cops on request without a warrant. Now, I expect this decision will be appealed, and we'll see how that all goes. If you've made it to the end of this video, you're likely someone who should subscribe to this channel. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. There's a bell thingy to get notified of new episodes. Also, leave a comment if you have any questions or if you have any suggestions for other topics you might want me to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian privacy law. Thanks for tuning in.